Today we are talking about the FTC ruling on non-compete agreements. So let's start off with talking about what these are. If you're not aware, a non-compete agreement is something that's fairly common where an employer signs a contract with the employee, basically limiting the employee and what they can do if they were to leave the company as far as next employers. A lot of times they're limited by industry or function, or sometimes specific competitors are called out. I've actually signed one of these before. They're very common. A lot of places consider them very difficult to enforce. The courts have been rather skeptical of them and require employers to show a strong case for why they need one. Also, interestingly, I learned researching for this topic that spa employees are often signing these agreements, which I found interesting, which is really not about intellectual property protection. That's more about protecting their sales list, their client list. So let's talk about what the FTC did. They basically issued a rule. It's been in the pipeline for a while. They've issued a comments period. They have received those comments, and now they've issued the final rule. It's interesting where this is a new authority that they're claiming. You can see here in the Wall Street Journal, the FTC says it gets that authority even if it has hardly ever been used from an obscure section of a law that created the commission in 1914. So it's rather interesting that they're using a newfound power that they found in the law that hasn't been used for over 100 years. So obviously they're getting a lot of pushback. Ryan, a company appears to be Texas, has issued a press release. They mention in their press release that, quote, Ryan sought to dissuade the FTC from this action by submitting last spring a 54-page public comment against the FTC's proposed rule. So they were on this early, and 54-page public comment is pretty substantial. They go on. The FTC's decision to ban an important tool for protecting IP will inhibit firms from investing in that IP in the first place, resulting in a less innovative economy. They contend that the FTC lacks the authority to prohibit non-compete agreements. It also argues that the FTC itself is unconstitutionally structured. So not just fighting against this ruling or this rulemaking, they are saying the FTC itself shouldn't exist. So they're really not holding back. It's interesting to note that there are exceptions. Healthcare as an industry is exempt from the FTC, as is the banking industry. So those are two very large industries that if you're in those, this ruling will not apply. And also senior executives are exempted, and senior executives are defined as people making over $151,000 a year, which actually is going to exclude a lot of tech employees, which is actually a realm where we see a lot of these agreements. So a lot of people are not going to be impacted by this, but some will. So let's go on. CNN, thinking about the impact. So what does all this mean? The FTC contends that businesses seeking to protect their trade secrets and other confidential information can do so through the use of confidentiality clauses. So basically, the FTC is contending here that there are other ways to accomplish what these employers want. And I think that's accurate. Confidentiality clauses. I think non-solicitation clauses are another avenue that you'll probably see. And in fact, as you can see here, 3 other states, California, North Dakota, Oklahoma, and Washington, D.C., already have near complete bans on these agreements. So I don't think this is going to be the calamity. It might be tough for some businesses, but I don't think this is going to be a huge impact on the economy. I don't think it's probably a net positive for employees, somewhat of a concern for employers, but they have lawyers. They will find other ways to accomplish the business objective that they have with these agreements. I don't think they really care so much that people are going to other firms. It's that they don't want them taking their information or their client list with them. So, and finally, I would just point out, you'll remember in the early 2000s that several large Silicon Valley employers settled a class action lawsuit where they were accused of conspiring to not poach employees from each other's business. This is pretty blatantly illegal, at least according to here. I have a page from Wharton, and they here state that it is an unreasonable restraint of trade and a violation of the Sherman Antitrust Act of 1890. So basically, companies colluding to not compete for customers or to compete for employees is pretty heinous. So this is this is what these employees are up against. And I think is important to remember when you think about how employers are dealing with employees. This ruling is obviously a pro-employee decision. We'll see if the courts agree that the FTC has the power to do it. But in any case, thanks for checking out today's video. Please drop any comments you have, like and subscribe. We'll see you next time.